Thank you,
Good
Sita.
afternoon. Thank you, Sita. It's Chris Martin here. I'm still getting used to all this virtual stuff where I can't see smiling faces in front of me. But thank you for joining us. We're going to discuss mental health and human rights in the workplace. We thought this was a good topic to explore, given the stresses and anxiety and pondering that COVID has brought not only to individuals, their families, but in the workplace. And it's magnified issues that we've dealt with for a number of years about mental health and dealing with mental health in the workplace. I think most of you know us through your invites or not. I'm Chris Martin. I've been here at Lindsay Kenney for 20 plus years. I'm a partner out in Langley. I've practiced litigation, including employment law, shareholders disputes, personal injury, all types of litigation. Well, one of the significant parts of my practice throughout has been employment issues, both on the employer-employee side. Tamara, who's going to start off the introduction about just giving an outline of mental illness and how COVID has increased the anxiety and increased difficulties in the workplace, obviously, because of the restrictions, everything that we have to do interacting with customers and ourselves. Tamara has been practicing for a number of years. She's quite experienced. She just recently became a partner out here in Langley. She's developing an employment practice. She's interested in workplace investigations and sort of mediations, in that human rights have been quite a focus for her in those investigations, in that if there's allegations that an employee makes against an employer, we'll talk about what an employer has to do, but one of them is to investigate and arbitrate them fairly. So from there, Tamara is going to give a background. I'm going to then talk about the legal framework. I'm not going to get into the nitty-gritty, but it's helpful in sort of assessing where you're at in the workplace and what you can do to identify issues and understand the responsibilities that you have as employers. And when you see those issues, then sometimes you might say, well, perhaps we should give somebody a call to see if we're doing this right, or what we can do as an organization to make sure we're compliant and promoting a safe workplace and avoiding all sorts of claims and the like. So with that, I'll hand it over to Tamara.
Thank you, Chris. Today we are going to focus on mental health and what constitutes a mental disability. COVID has been hard on everyone, and it's been particularly hard on employees and employers. At this time, we're fielding so many calls about what happens if someone refuses a vaccination. What if someone's afraid to return to work because of fears of COVID? COVID has had a hard impact on the economy, and it is raising a number of significant human rights issues. So we thought we'd do this seminar to caution everyone. There are grounds to ask people to get vaccinated. There are grounds to enforce mask mandates and things of that nature. But what are we going to do with the mental health issues that are arising and mental health implications when people are starting to return to work, which is going to be significant. So the overview today is we're going to look at COVID and its effect on the mental health and employee expectations. We included that because that's an important aspect of what we're going to delve into, what employees expect coming back into the workplace, the safety issues, also the disclosure of personal information. Can you ask if they've had a COVID vaccination? Can you ask about their vaccination status? Can you require, mandatory vaccinations? And what if someone says, I can't return to work, I'm too stressed out because of COVID? What are your options then? In all of these situations, you have to think about the human rights code, the implications, because they will arise. And right now, the Human Rights Tribunal is extremely busy with COVID-19 issues. And there's quite a backlog on the Human Rights Tribunal, although recently in Alberta, their Human Rights Tribunal issued a statement on the mask mandates, which has provided some guidance and says that it's not per se discriminatory right at the beginning. So Human Rights Code, why does this apply? Human Rights Code protects all employees and workers. It includes prohibitions against discrimination on many of the basics that we understand: disability, sex, race, color, language, religious, political, but mental disability is also included as one of the factors that we're going to look at under the Human Rights Code. What's your duty as the employer? If you're facing a human rights potential claim, you certainly want to be protected in that regard. But what do you have to do to accommodate your employee? To what lengths do you have to go to? Now, the duty to accommodate can be stringent on employers, because you not only have to be able to ensure the employee is able to work, because if there's a termination and they have a valid protected human rights category, you could be exposing yourself to a human rights complaint in the tribunal or a lawsuit. But what do you have to do as the employer? How far do you have to go? And the test, which Chris will delve into in a little bit more detail, is called undue hardship. And that's a high burden to reach. It's not just an inconvenience to you as the employer. It's you have to make accommodations to these employees to the point of undue hardship. So we'll delve into what that means and what you have to do as an employer. So let's take a look at the next slide and look at what's going on mental health, because we have never really seen such a significant increase in anxiety and stress-related claims, and it seems to correlate exactly to the COVID pandemic. And this is just common sense. I mean, we're looking at what people are going through. They're concerned for health and safety. Many people have lost loved ones. Many people are, concerned about and opposed to the vaccinations. For certain reasons, regarding testing and other matters. Whatever side of the fence you're on, COVID is going to play a big role in employee mental health. And that's been looked at extensively in various studies. We looked specifically at studies that dealt with what employees are going through. And the main 5 issues that they were dealing with are what's referred to as job insecurity. So job insecurity is simply that, concern about losing your job. Many people in the last year and a half have lost their jobs, or they faced a reduction in pay or benefits or contracts. Many people work on an independent contract basis, or a reduction in clients. We've seen significant amount of business closures, and then there's the related stress that comes with that, with people just not being able to afford to live. So, and there still remains a question about what impact is COVID going to have on the economy moving forward. So there is a lot of job insecurity that's resulting in an increase in mental health issues of employees. The second one is safety. When we talk about safety, we are talking about the employee's personal safety. And we will look at the obligations of employees and employers moving forward in regards to COVID safety. I hope and assume that many of you out there have a COVID-19 safety plan that is mandatory now, that will delve into what happens with COVID exposures in the office, who to report to. You should have a written plan that's available to all your employees to deal with this, dealing with remote work from home situations, and what happens when someone has to isolate because they've either had COVID or if they've had an exposure. Family health is the third one, and that's an important aspect too. I mean, many people have elderly parents, many people have children. They're concerned about exposure with COVID, or they're taking care of a family member who has been ill with COVID. Again, that creates a financial impact on many people. Childcare is the fourth issue, and that's been a very difficult one for parents. I'm sure many people on the seminar can relate, but with COVID coming into the situations, we looked at school closures. We looked at limited availability of preschools, limited availability of people able to provide childcare services during this pandemic, which has resulted in a significant amount of people actually resigning from their positions and working from home, predominantly female. And so that's been a very difficult issue and has caused an increase in mental health issues. with employees. And then the final one is disruption to personal and work life. This was the fifth factor that most people in the surveys had found, that with school closures, lack of social interaction, restricted travel to go see grandparents or other family members, and working remote has resulted in social isolation, and many people are having a difficult time working through this period. We are having a gradual reentry, but these are the 5 main factors, and there are others, but these are the predominantly 5 major risk factors that employers are concerned about when returning to work, or what they will see in the future. We'll go to the next slide, and we'll look at why mental health issues are important. What we're seeing is a significant increase in human rights claims, significant increase from our clients who are employers. What do I do when someone has mental health issues and are dealing with these things? So because of the gradual return to work phase that we're in, there is a concern for particularly high risk work environments and occupations. Recent study with the World Health Organization released a report on preventing and mitigating COVID-19 at work. They emphasize that workplaces with physical or person-to-person interaction are highest risk. That's particularly in the healthcare factor, doctors, nurses, acupuncturists, massage therapists, physiotherapy, anything that's dentists in particular. This is a high risk area that people are in. Other high risk employees include retail and production workers, restaurant and hospitality workers, transportation and construction, and also one thing that's not often identified is the social service occupations, social workers and counselors. Many have moved to Zoom, as you will see. Chris and I have done a lot of Zoom meetings in the last little while, but there's many professions where you're simply going to need face-to-face interaction with the client or the patient. So these are some of the concerns going into high-risk occupation. Another factor that they found was inadequate ventilation has caused serious problems, and then shared work environments. So let's take a look at some of the obligations and responsibilities we're going to have to deal with. We're dealing with mental health issues in employment. So one key thing I want to look at is your employer's obligations. What are the employer's obligations to ensure a safe workplace? I think this has to be communicated to the employees, that you have policies and procedures, which are mandatory under WorkSafe right now. You should have a safety plan in. And another key thing is to have open communications, because as an employer, you have obligations to ensure that your workplace is safe and healthy, and ensure the safety and health and well-being of not only your employees, but clients coming into your business. So COVID-19 at this point right now is considered what's called a workplace hazard under the Labor Code of Canada. So if you have a union or you're dealing with unionized employments, the Labor Code is going to apply to you, and COVID-19 does constitute a workplace hazard. If you're dealing with employees not in a unionized setting, you're looking into the Employment Standards Act, and you're also dealing with OSHA, which is the Occupational Health and Safety Act. Something you need to be familiar with, because during COVID, there has been a significant number of audit inquiries and OSHA regulators showing up to workplaces to ensure that they are in compliance with their COVID-19 safety plans. Also with the new vaccination passports, I believe we're going to see more audits on companies moving forward. So let's take a look at what is the Occupational Health and Safety Act, what it's going to require to ensure workplace safety, and to address mental health issues that we're dealing with. OSHA, the OSHA, the Occupational Health and Safety Act, does promote occupational safety, and it protects workers from work-related risks to their health, safety, and well-being. And again, in British Columbia, that will include COVID-19 exposures. Now, the studies that we've looked at have shown that a significant issue for employees is job insecurity and lack of income when they're sick with COVID. I wanted to raise just this one issue under the Act, and compensation, potential compensation. They don't always meet the factors. If someone does have a COVID exposure at the workplace, they will be entitled to compensation if these conditions are met. First, Is there evidence that the worker has contracted COVID-19? That evidence can be supported either through a medical diagnosis or non-medical factual evidence or other evidence, system cluster, referred to often as an outbreak, establishes the existence of COVID-19. The other factor that they will look at is and this is key, the nature of the worker's employment creating a risk of contracting the disease that is significantly greater than ordinary exposure risks to the public at large. So there can be compensation through workplace exposure, but again, it's imperative that you have a work safety plan in place. And I think that will assist with concerns that employees have coming back to the workplace, because that was one of the main mental health challenges that they were facing. Take a look at the next slide. What is another issue that employees are facing when they're coming back? First, anxiety and stress coming back to the workplace because they're concerned about safety risks. But the second major issue has been disclosure of personal information regarding COVID-19. There are competing sides to the story. One is the public safety. Employers and employees need to know if someone does have COVID and if they can potentially expose clients and other employees to the disease. And that can be a potential liability for employers if you don't have the right policy in place and reporting procedure. But the other aspect is, and many employees are concerned about this, is their disclosure of their medical health information, disclosure of personal information regarding COVID. Again, just briefly looking at the Federal Labor Code, an employee can request COVID-19 information if it directly relates to ensuring their health and safety of their employees in the workplace. And I will also include clients in there. One, if they're exhibiting any symptoms of COVID-19, or if they were in close contact, or if they've been traveling internationally. Another aspect that you have to discuss regarding personal information disclosure, because I know a lot of companies are now instituting vaccine policies in their workplace, mandating that everyone has a vaccine or discloses what their current vaccination status is. You also have to be aware when you're dealing with privacy issues that there are some risks and liabilities. In British Columbia, there's the act called the Personal Information Protection Act. And this simply states that employers or organizations must not collect, use, or disclose personal information of their employees without consent. Now, PIPA does not require consent for collection, use, or disclosures for purposes of establishing, managing, or terminating the employment, which is a very important exemption for employers. The key, though, is so long as the employee was notified that their personal information could be used for this purposes. So once again, as part of your obligations to maintain a safe workplace, this exemption could be used for the collection of employees' COVID-19 status. But again, I have to emphasize that the Act specifically says that the employee had to be notified ahead of time. And so again, I emphasize the importance of a written employment contract that includes the PIPA requirements and the consent. So let's move on to the next slide here. We're going to look at mental disability and mental health. Chris is going to talk to you about what are some of the requirements under the Human Rights Act and what we need to do for disclosure in regards to mental disability, and whether most mental health issues, do they fall under the ambit of mental disability to entitle them to be protected by the Human Rights Code. So the Human Rights Code we discussed briefly, but it prohibits discrimination based on personal characteristics of a person that is employed with you, or even a prospective employee. So when hiring, you do have to be aware that you cannot discriminate. Common ones: age, ancestry, criminal conviction, family status, gender, religion, and mental disability. Now, mental disability is not specifically defined in the BC Human Rights Code. However, it's entitled to full protection just as age, race, or sex. There was an important Supreme Court of Canada decision called Gibbs v. Battlecourt, and that ruled that all these different protected categories are entitled to the same equal treatment and equal protection. So in that case, the court found that an insurance company's policy of providing long-term disability benefits to employees age 65 with physical disabilities, but only 2 years for those with mental disabilities, unless they were institutionalized, was discrimination because it treated two forms of protected human rights categories in a different manner. We'll go to the next slide. So what is a mental disability? And this is something very important that I want you to understand in the seminar. Not all mental issues are going to be viewed by the tribunals and the courts as a mental disability. Mental disability, once it's classified as that, will entitle the employee to many protections under the Human Rights Code. But not every mental health issue is going to constitute a disability. And a frequent common sense issue that comes up, what about stress? What about anxiety? So those will come up, but that's going to be on a case-to-case basis because not all of the general stressors we see in life, or even the anxiety from COVID-19, is actually going to constitute a mental disability. So mental disability can include something that affects person's abilities, developmental disorders, learning disorders, a diagnosed mental illness, depression, bipolar. I do want to make note of alcohol and substance abuse. This actually will constitute a mental disability under human rights and employment disputes. And then, as I emphasized, anxiety and stress disorders, but not all of these type of disorders will constitute what's called a mental disability. So if I can break it down into three elements, here's what you're going to be looking for. The mental condition prevents the employee from performing significant functions that can be performed by others. It's an ongoing issue and it is beyond the employee's control. Next slide, please. Great. So Chris is going to talk to you about more of the legal aspects of what's going on with the Human Rights Tribunal and what your duties as an employee and your obligations as an employee are. But I did want to raise this this is the final PowerPoint in my presentation that you want to be aware of. The Human Rights Tribunal had recently released this report regarding proof of vaccination, and I want to just emphasize that they were focused on the balance between protecting human rights versus the urgent public health care. So what they said is no one's safety should be put at risk because of others' personal choices not to receive the vaccine. However, just as important, no one should experience harassment or unjustifiable discrimination if there are effective alternatives to the vaccination status policies. So this is going to be a new issue that's coming up frequently. Long story short is that generally the courts and the Human Tribunal are going to put public safety over private choices, but you do have to go through a human rights analysis, which can be tricky, and make sure that you're complying with the duty to accommodate, which Chris is going to discuss in the next presentation. So thank you.
I've unmuted myself. When I began, any questions you have for us, you can wait till the end and ask us. And there's a Q&A button at the bottom of your screen. So if you want to type in a question, you can do that as well. Just touching upon this issue of rights, and I think Tamara's given somewhat of an explanation of it, but it's a common thing that's used in general parlance. That it's my right to do this, it's my right to do that, we're free, we have liberty, I can't be restricted in any way. You've heard that a lot in the government restrictions that have arisen. There's a distinction of what the Human Rights Code deals with, and that's really an individual's right to certain aspects of daily living, and it's basically a right not to take away something. And the taking away is limited to those areas that include employment that we're here for, but housing, services, membership in associations and publications. The notion being that if you're an identifiable race, that you shouldn't be precluded from access to an employment. Somebody can't make a decision based on your race that you shouldn't be employed, or make a decision that I'm not providing you a meal service because of your disability. Those are what are the rights that are protected. It isn't an individual right under the Human Rights Code has never protected the idea that you can do anything within society. It isn't, and why that's important, what Tamara touched upon, is with masking, for instance. It's my right not to mask. Well, that's balanced against the collective view of how to be safe in a workplace, and it's about reasonableness, which we'll talk about in framing things. That the Human Rights Code isn't involved in asserting rights. It's involved in protecting rights and looking at the reasonableness of the situation. So that's one of the things that I think we kind of think about. People throw rights around. I'm free to do whatever I want in a free society. That's not what the Human Rights Code is associated with. It's about protecting those with identifiable characteristics from being precluded. And that's been because historically, the disabled, whether they're mentally disabled or not, have had more access difficulty in the certain daily aspects. So we just move on to the second slide. And as Tamara talked about, mental illness is defined, or is a recognized disability. Within the code, it's just disability. And for years, mental disability was the most difficult thing to deal with because of the personal nature of it. It was also wrongly, there was a taboo to stress, depression. Those are the kind of things that people carried on their own and thought, well, I could just get through it. You know, a broken leg's easy to fix, but why I'm not feeling up to working or why I can't get out of bed, we've now at least laudably and enlightened ourselves about the difficulties of a mental illness. For instance, I think today, for you, those who are involved in sport and see all these athletes who are at their peak physical form. There's a hockey player for the Montreal Canadiens who didn't play last year, and everybody was inquiring why he couldn't play. And one is, you shouldn't be inquiring, but it's been disclosed that he has an anxiety issue that precluded him from participating in the sport last year. So we've come a long way to recognize that these types of illness are the most difficult for the individual, but for employers, and because they're not identifiable. Somebody comes to work and you expect them to do their job. If you don't speak to them, that's not unusual. They come and they go, and I'll touch upon things at the end of the my discussion about how you can inquire and make yourself alive to those issues. But and it's one of the things that why we thought today was a good point to discuss it, because of course COVID is, as Tamara's touched upon, is increasing the intensity or anxiety and stress in the workplace. And hopefully we all get through this soon, but for the time being. So if we go on to the next slide. One of the things that we always struggle with is trying to explain, okay, well, what are my responsibilities as an employer? And it is a useful framework of, it seems like common sense, but it is that where you could be exposed in a situation of running your business or trying to deal with employees is that you have an individual who has a protected characteristic, in this context, mental illness, and where the link is that it's an allegation of negative treatment, or there actually has been negative treatment. So there has to be something in the workplace that has adversely affected the employee. And I've put some examples in that, but where they arise, where Tamara and I usually see them is an employee has been terminated. That's the number one thing we usually see them, but there's other ways you could adversely, or an employee could be adversely affected. They're demoted out of a position because they're not performing. The job duties are changed, that they don't like that, but it was in the context of a work performance issue without realizing the work performance issue was tied to a mental illness. And then, of course, negative comments about an employee, which we've, as I progress over the last 20 years, those become less and less as we all become more and more enlightened and aware about workplace culture. But the one we deal with the most is a termination in which sometimes the employer has no idea that an employee was suffering from mental illness, or that they may have had a view that things had changed with the employee and they thought it was performance related versus what the employee was struggling with. Why they've made a sort of drastic change was that there was a mental health aspect of that. I'll talk about the duty to inquire in a moment. But then, of course, you have to link all two of them together for that, the protected characteristics, the factor, and the negative treatment. And that's where we get employers saying, well, I didn't know about this. This was a performance issue, and I didn't know they were mentally ill. So a human rights complaint can't be successful against me. Unfortunately, that's not the case. And that's where it's the three elements of the claim in which, as an employer, you have an ongoing duty to ensure that the workplace is safe and making sure your employees are not suffering within the workplace or needing assistance in their duties. If we go on to the next slide. But that doesn't end the matter. So if an employee was bringing a claim, they would have to establish, look, I have a protected characteristic, I have a mental illness. Usually that's certified by a medical practitioner. Then they have to identify the negative treatment. For an example, that's the termination. And then they have to combine the two, which once you have the first two, the third element of the test isn't that difficult to link. But it doesn't end the matter, because it's not unrealistic on employers. Because if an employee cannot discharge their duties because of a recognized protected characteristic, you're not required to keep them on just as a matter of course. The employment bargain is you pay somebody to do work for you, and you need to get something out of that. But unfortunately, it isn't just a straight, here's your paycheck, you do the job as I tell you. But if I come to you and say, I need some assistance, then you have to make reasonable efforts to assist. In the context of a mental illness, we'll talk about accommodations or modifications in the workplace. But of course, it's not an endless duty, and there's always the question of reasonableness in law. And the problem with employers, and especially small scale employers and medium scale employers, is, all right, well, I'm trying to run a business, I'm trying to be profitable. To take these extra steps, it's going to make the employee less, or our workplace less. There's more layers and it's more difficult, and profit is one of the things that they're looking at. But I think that there is ways to address those points, and there's ways to look at things practically and pragmatically that will assist you in dealing with the mentally ill. And I say that because what happens, and it's happening less and less, but what would occur is those that were depressed or anxious or bipolar, those kind of diseases, they would simply just exit the employment field because they didn't want to discuss their illness because of the taboo on it. But now, as the taboo is being lifted and it's being recognized as a common day-to-day thing with our colleagues, is that they're going to want assistance moving forward in the workplace. So it's something that I think will continue to grow is how employers deal with these issues and how they manage their workplace to avoid these issues. So we go on to the next slide there, Sita. Just going back to the legal test, so how you could say that, look, this employee, despite their illness or the protected characteristic, cannot fulfill the job that we've got for them. And that would be, it's a 3-layered test about what are the standards you're imposing for the performance of this job. Now, it's, for instance, if you have a sales rep and the standards are so reasonable or so unreasonable that they can never meet those targets, that would be something that they want to look at rationally about what are you imposing on this employee. Then then whether it's honestly in good faith, because one of the things when you're got a problematic employee is, okay, well, we're going to give them this work to do, and we want them to fulfill a job duty on the basis that, well, they could never do that. But of course, if you do such a thing and you're not acting in good faith, you won't be able to justify your performance. So it has to be rationally connected, and it has to be a legitimate and good faith effort to include the employee in the workplace. And then again, we get the reasonably and necessary and a legitimate workplace. So it's taking the 2 steps and saying it would be impossible to accommodate the person any further. We've taken all our steps to try to assist this employee. For example, let's look at this in the context of mental health and in COVID. For instance, that we tried to work with the employee and have them work remotely because they had a medical note about the anxiety of coming into the workplace. And we tried to then set a schedule and have them work remotely from home. And that worked for a couple of months, but then the employees stopped participating. There wasn't as much work. Those are where you start looking at, is it a reasonable accommodation? And once that accommodation is done, did you look at alternatives about bringing the employee in? And so it can be quite a layered process, but that would be some of the steps that a trier of fact would inquire is, okay, what steps did you do to assist this employee, and was it a reasonable in the circumstances in that you still get value from the employee in the workplace. So if we go to the next screen, this is the undue hardship requirement, and it's quite a difficult bar for employers to satisfy, but it's really what your legal duty is to accommodate somebody that you're aware of that's ill and needs accommodation in the workplace. And it means that you're, as an employer, required to suffer some hardship, not an undue amount. And that's not very helpful in that none of us want to, as employers, suffer hardship. And what does undue mean? It means that it's a high bar, or it's difficult for an employer to justify or quantify the level of hardship. But in certain circumstances, the financial cost relative to an employer's size, and that would be taking into account a small operation and ability to withstand somebody working 50% of the time or 25% of the time versus getting return for that investment in the employer. In a union setting, it would be the disruption of the collective agreement. Would the accommodation be outside what the 2 parties have negotiated for all their employees, and what kind of expectations it would be put on? There would be issue about morale of other employees. What happens sometimes is you make an accommodation, have somebody working at 50% of the time, and the reality is there's nobody to replace the other 50%, and other employees are left carrying the bill for the ill employee if you get to that place where you can't fulfill that obligation, going back to financial costs of whether you could hire somebody to work part-time to fill those things. the interchangeability of the workforce. I'm not sure what that definition is, other than that it is something where you're having it all is fact specific to your workforce, whether these are highly skilled or skilled positions which are easily replaced. For instance, if you have a receptionist who's suffering from mental illness, says to you, look, I can only work 50% of the day, that would be something where it would be unlikely that somebody would say, well, it's not undue hardship to find somebody else to cover the other half of the day. There's people that can fulfill those positions, versus somebody who's flying a helicopter on a schedule that for your workforce. The adaptability of the facilities, that goes more to physical disabilities, but there are certain things that mental health can be assisted in looking at, depending on the diagnosis, depending on the doctor's recommendations. There could be things where you can adapt your facility to assist the employee, and then the magnitude of safety risks and identify those. Those become more with mental health, where you're in a high risk job and you're dependent on alertness and the avoidance of prescription medication to control, for instance, depression. Those kind of things can arise if you're putting your safety and others' safety at risk, trying to manage the illness. Then that becomes a factor in assessing undue hardship. So if we go to the next, this is the kind of pragmatic advice that that we get all the time. Is okay. Well, what do we do? Well, number one is don't discriminate. But that's I think living in the society that we live in, nobody does, and nobody. One is being aware of all aspects of the code and how you could fall into discrimination. But I would think that, and in my experience, 90 to 100% of employers are aware that they need to create a workplace free of discrimination and need to create a safe work environment. And Tamara touched upon this when she talked about occupational health and safety at the Act, and what we've done now for COVID's the main issue. But there's also bullying in the workplace. There's things that can affect mental health, and you just have to be compliant about those policies and procedures. And that's pretty much common sense. But the second point is creating a workplace culture. And the workplace culture is what we've talked about here, going on 40 minutes, is there's no taboo in mental illness. There is no shame in that, and that people should be aware that there's stresses at work. There's stresses in life, but there's stresses in work. And that's where the workplace can come in, is one, being open to the discussion, and two, giving resources to the employees to, one, discuss that on a confidential basis, and understand in certain aspects there's employer ability to assist somebody who's struggling with depression or struggling with mental health, other mental health issues, struggling with addiction, and create the awareness to the employee that they're not alone in this, and that if they need assistance, that the employer is willing to provide it. It's also it's just a pragmatic way to run your shop, in that those that are suffering from those illnesses can create loss, can create division in the workplace, and it's good to assist before it becomes a problem. And then being aware of the signs of mental illness. I'm not a mental health expert. I'll tell you, I was in court in July, and my client had a breakdown. He was being cross-examined and had a breakdown, and the judge said to me, Mr. Martin, I'm concerned about your client's safety. I want you to take the break and determine if you can continue. And the first thing I said is, well, I'm not qualified for that. And so I called doctors, his doctor, I called other doctors, and went from there. But that's one thing that happens, and as an employer, you have to sort of disengage from that, especially in close employment situations. Is you can't be the employee's confidant. You can't be trying to assist them or giving them advice about how to deal with their mental illness. You should be directing them to professionals and understanding when to do such a thing. And those are sort of the common signs. And I'm sure I'm not telling anybody on the line here that, but some of the common, somebody who's always at work on time starts arriving late. Then they start missing work, and the absences become more and more sort of odd. The stories can get they can't keep their stories straight. Their aunt was ill, and then their uncle was ill. Those kind of things, and then somebody who's been cooperative and engaged starts becoming difficult with all his or her colleagues. Decreased productivity, that's pretty much common sense. And increased accidents or safety issues, that's a sign. And the one thing is that the decrease in concentration or remembering things. And then the up and downs, where they're one days seem disengaged, and the next day they have great plans for their work week and their workspace or for the goals of the employer. And then just decreased interest or involvement with work, and then of course anger or blaming others, that becomes an issue for the employer at the just at the outset of any anger or blaming, is that it becomes an employee on employer issue or employee on employee issue. So that's where you can intervene and sit the employee down. But as I said at the outset, you're not the confidant. You just want to give the employee an ability to express themselves, and then make sure they get the help that they need, which isn't from the employer, it's from the professionals that can give such help. And the next thing is, I think, medical information. I think Sita took away my notes, but there they are. Medical information is something I think we've touched upon on a previous. You're entitled to gather medical information. An employee comes to you and says, look, I'm suffering from an illness. You have, one, a duty to inquire about that illness, because if that illness is being untreated in the workplace, it could cause health and safety issues. And you need to know how to deal with it. So you have a duty to inquire. But of course, that information is confidential, and you have to treat it as such. But it doesn't make a note from a doctor saying an employee is on stress and won't be back for 6 weeks isn't good enough. And you can ask, you can form a letter or ask the employee to take it to their doctor and ask about the general nature of the illness and how it manifests as a disability. For instance, how is it affecting this employee in their ability to return to work, whether the disability is permanent or temporary, and seek a time frame for when it will be reassessed. Doctors sometimes will write notes that, well, they'll be off until they feel better. Well, that really isn't of much assistance at all. So you can say, well, look, when do we expect this employee to be back? The restrictions, if there's certain duties that the employee can come to work, but she or he can't do something, well, then have the employer specify that, and then go back to how long that's going to be and when they think that they will be able to be fully back to all of their duties. Within that, you need to have an ability to succinctly and accurately state what the employee does and what your expectations are of them. And then, if you're getting more and more concerned about the legitimacy of this illness, you can seek further medical information, including a clinical records or treatments of medications. But I would take it as a staged approach. Sometimes at the outset, just detail about a timeline, the illness, and the expected return to work. And then, depending on how the matter plays out, then you can make further inquiries. I wouldn't be asking for clinical notes and a full medical history at the outset. It just depends on how it progresses. But then if things continue on, you can get second opinions and independent medical examinations. But hopefully that doesn't occur. But there is, what you should take from that is there's layers of medical information you can get from the employee. One is not only to satisfy yourself that the illness is legitimate, two is to understand how you can accommodate the employee in the workplace. And the employee has a duty to give you that information. If they don't, once you inquire, then they're not going to be very successful in bringing a claim against you, because you've made the reasonable steps to inquire about the illness and seek the medical information and seek the information you need to assess accommodation. How do you know how to accommodate somebody if the doctor isn't telling you these are the problems and this is what needs to be addressed? And then at the end, they're saying, well, this was the diligent, reasonable, and genuine. We touched upon that earlier on, but options currently, options evolve. Working remotely is an option. Some workers, we've got most of our staff who come in and out of the office. Some are very good working remotely, some not so good. Some like to come into the office, some don't. But there is that common issue of accessibility that I don't think was 2 years ago before all of this happened, about working from Zoom and working from home. That's been an area of accommodation that's going to be looked at closely. But as I touched upon, and sort of generally, flexible or modified scheduling. Employee needs modification in their work. They can't do 8 hours. They need to take a break. They need to go home for 2 hours during the middle of the day. Accommodating a work schedule, depending on the timelines in the organization, most could do that, find alternative hours to work. For instance, if you needed somebody to do, let's say, data entry, and they were currently concerned about being in an office with others, would you be able to do it if they came in at 10 o'clock at night and worked till 4 o'clock in the morning, or something after hours, 6 o'clock at night? That would be something that would be a modified work environment or schedule. Modified supervision. If somebody's struggling with the stresses and anxiety of a job, it may be that they need a trainer or a supervisor really working them through what they're doing to the point that they're independent. Modifying job duties, that's pretty common sense. And then, an individualized rate of absenteeism, not recognizing we're all the same, and recognizing somebody who's suffering from a mental illness may have to take more time off work. And that's something that you can assess on an individual basis. And if a doctor certifies, look, they can only work 4 days a week, or they need to take 2 personal days. And then reassignment, that's within the duty to accommodate, is finding another alternative position for somebody to work in the market, work in your operation. All right. That's all I've got for today.